Okay, so we have the UCC connection. I've had this book for a while. It's always good to refresh your brain and stuff, but this back page, full circle. So we're gonna read it. Special stuff you should know. Taking your birth certificate to court. The courts only want to charge some bogus bonds to your federal account, and they need your bond or permission to do the discharge. Otherwise, you must pay a fine and go to jail. But they neglected to tell us that the birth certificate is a bond, and the birth certificate is proof that we are the beneficiary and not the trustee of our strawman trust account. The state is the trustee. Everything, including crimes and taxes, is already prepaid through the birth certificate bond. In every case so far, the charges were settled and they let the fellow go without a record of crime by surrendering the birth certificate. Further, the birth certificate proves that you are the beneficiary of your strawman estate. The prosecutor is claiming that he represents the beneficiary when the estate is really supposed to be the trustee. So when you bring your birth certificate into court, you discharge all of the charges against you and you prove that you are the beneficiary of your trust estate. And this completely shuts the prosecutor down. The prosecutor now has no standing. You bringing in the birth certificate proves that he has brought fraud into the court by claiming to be the beneficiary instead of you. Only the beneficiary, who is you, can be the plaintiff. And only the trustee, the state, can be the defendant. I do not give legal advice, but this is what I would do if I were in your shoes. How to proceed. 1. Take a certified copy of your birth certificate, which is certified by the state, to court with you. Do not take a copy or it will be void, and do not have any markings on it or it will be void. 2. Write down what you're going to say because you can be nervous and forgetful. 3. When they call your name, walk up to the bar, but do not cross it. If it is a court of record, ask them, are we on record? Once you are satisfied you're on the record, you can proceed. If they ask your name, ask again, are we on record? 4. Hand the birth certificate across the bar and say, I am here on special appearance. Let the record show that the person and the birth certificate has been surrendered to the courts. If they will not come and take the birth certificate, then gently toss it across the bar into the well of the court. Special appearance means that you are not giving the court jurisdiction over you. 5.
Check this out. However, to reclaim your credits and vouchers and set up such a system requires that you participate and reclaim your American state national, right? American state citizen status. Every American who completes the paperwork to return their good name to the land and soil of an American state is eligible for repayment credit. All members of our actual state assemblies will, by definition, be eligible. Check this out. Some of you have asked about Peter of England's debt eradication vouchers. These would transfer credit from the DoD stockpile to offset debts owed to American state nationals and American.
The Bill of Exchange Act literally tells you what to do.
It literally tells me, endorser, payee, if you endorse it in a timely manner, it shall be accepted. Even if you don't endorse it in a timely manner, okay? The Bill of Exchange literally tells you what to do with a past bill, an overdue bill. Literally tells us what to do. Accept the goddamn bill that's getting sent to your goddamn house every first of the goddamn month. Why are you going to work? Why are you paying a bill that's already paid? It's sitting in an account waiting for you to transfer it to the principal's account number.
When you enter into a court setting representing yourself in propria persona, in your own person, or pro per, which qualified you as an attorney in fact. By asserting your private right to represent yourself in legal matters, it establishes your status as your own attorney. To proceed in pro per, that means that the court cannot impose the same standard upon you as imposed on a bar licensed attorney. You can then state, I move this court to vacate this judgment because the court's jurisdiction was procured by and through fraud. Your next subject title will be Facts of the Case. The bank and third-party debt collectors operating by and through fraud. All commercial instruments such as promissory notes, credit agreements, bills of exchange, and checks are defined as legal tender, or money, by the statutes such as 12 U.S.C. 1813, 1 and 1, UCC 1-201, 24, Section 3-104, Section 8-102, 9, Section 9-102, 9, 11, 12, B, 49, and 64. These statutes define a promissory note or security to be negotiable, i.e., sellable, because it's a financial asset. This is all necessary because contracts requiring lawful money is illegal, pursuant to Title 31 U.S.C. Section 5118 D. 2. You see, all Federal Reserve notes are registered securities and promise to pay in the future. They are secured by liens and promissory notes of the collateral owned by the real people. The Feds uses these promises of the people's collateral to secure their notes. You see, if people want their commercial instruments to be legal tender, they must be secured by a maritime lien on your prepaid trust account, recorded at the county and registered on a UCC-1. It then becomes a registered security and a financial asset, which then can be negotiated. Therefore, when one has a bailor contract filed on a UCC-1, the bailor is never allowed to appear in their jurisdiction. One of the next title is the question of lawful consideration. The issue of whether the lender who writes and passes a bad check makes a credit loan has a claim for relief against the borrower is easy to answer, providing the lender can prove that he gave a lawful consideration based upon lawful acts. But did the lender give a lawful consideration? To give a lawful consideration, the lender must prove that he gave the borrower lawful money, such as coins or currency. He can have no claim for relief in a court at law against the borrower, as the lender's actions were ultra vires or void from the beginning of the transaction. Would a court of law or equity allow a counterfeiter to foreclose against a person's home because the borrower was late in payments on an unlawful loan? If it would be contrary to all principles of law.
Peace and blessings. So I'm reading the FDIC Act, or Federal Deposit Insurance Act. The term, and I'm at Section 3L1. The term deposit means the unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of business and for which it has given or is obligated to give credit, either conditionally or unconditionally, to a commercial, checking, savings, time, or thrift account, or which is evidenced by its certificate of deposit, thrift certificate, investment certificate, certificate of indebtedness, or other similar name, or a check or draft drawn against the deposit account and certified by the bank or savings association, or a letter of credit, or a traveler's check on which the bank or savings association is primarily liable, provided that, without limiting the generality of the term money or its equivalent, any such account or instrument must be regarded as evidencing the receipt of the equivalent of money. Evidencing the receipt of equivalent of money when credited or issued in exchange for checks or drafts or for a promissory note, upon which the person obtaining any such credit or instrument is primarily or secondarily liable. So the one who obtains the promissory note is primarily or secondarily liable for a charge against the deposit account or in settlement of checks, drafts, or other instruments forwarded to such bank or savings association for collection. Isn't that interesting? Peace.